2 days of hearings boiled down to about 4 hours of judgment reading. In court were 3 judges of the Court of Appeal, Justice Agnes Murgor, William Ouko, and Patrick Kiage. They sealed the appeal filed by the Independent Electoral and Boundaries Commission, seeking to review a High Court decision that votes cast, counted and tallied at the constituency level shall be announced and declared at that level before being transmitted to the National Tallying Center.
It is clear beyond peradventure that the polling station is the true locus for the free exercise of the voters' will.
The court also considered submissions from the IEBC that allowing the results to be announced at the constituency level is a recipe for chaos, and that the commission needs to have leverage in case there is an error that needs to be corrected.
It is, in our view, fallacious and flies in the face of the clear principles and values of the Constitution to claim that the chairperson of the appellant can alone, at the National Tallying Center or wherever, purport to confirm, vary, or even verify the results arrived at through an open, transparent, and participatory process, as we have already set out. Article 133(3)(c) buttresses this argument.
IEBC also wanted the High Court ruling reversed on account of dispute touching on the presidential election, which it held was a preserve of the Supreme Court.
That the dispute did not involve election of the president or any other issue under Rule 12(2).
NASA, which was the main respondent in this appeal, welcomed the affirmation by the Court of Appeal. Willis Otieno, who argued the case right from the High Court, says the rule of law prevailed.
You want to have an electoral system that respects the voice of the people, that respects the voice of the voter as expressed at the polling station, putting the polling station as the prima place that all issues elections are conducted and concluded. This
evening, the IEBC chair Wafula Chebukati, who had described the High Court ruling as a recipe for chaos, was more checked in his comments, welcoming the ruling but not discussing their next course of action.
We didn't go to the Court of Appeal to win or lose. What we were seeking in the Court of Appeal was interpretation of Article 138 of the Constitution.
This matter was ventilated on during the IEBC Joint Parliamentary Committee when the former chair, Isaac Hassan, explained to the committee the mischief behind having the results verified at the national level. Though the thrust of this ruling was based entirely on the Constitution, it's a second-round win for the National Super Alliance, who were the main petitioners in this right from the High Court.